Brexit continues to furrow brows in the UK. The latest hump on the road came after the meeting between British Prime Minister Theresa May and the President of the European Commission, Jean-Claude Juncker. Mrs May responded to a leaked account of the meeting with the accusation that Europe, Brussels, was trying to interfere with the British election on June the 8th. Although, as one writer put it, one can only assume that she thinks Mr Juncker wants to help Labour leader Jeremy Corbyn, in which case he has his work cut out for him. It's like trash talk before a big fight, isn't it? Professor Campbell McLachlan teaches law at Victoria University. We last spoke before the triggering of Article 50. Professor McLachlan is the only living author whose book was cited by the majority in the judgment of the UK Supreme Court on Brexit in Miller versus Secretary of State for exiting the European Union in January. In other words, ladies and gentlemen, he has cred. The outcome was that Parliament had to authorise the UK's withdrawal from the Union, as, good morning, Professor McLachlan, you correctly predicted. Since then, Theresa May, as I said, has called the snap election for June the 8th, and the Tories have just ridden triumphantly in the local elections. The Conservatives have gained more than 550 seats in local elections across England, Scotland and Wales. Labour's declined significantly. UKIP's facing a near total wipeout of its county council seats. In Scotland, the Tory who called Nicola Sturgeon a drooling hag has won the seat. Maybe it sounds better in Scottish. Drooling hag. No, not really. Welcome and good morning.
Good morning, Kim. Very nice to be back on the programme.
Nice to talk to you. The Tories will be happy that they've got some kind of mandate, and this may well be the result of Theresa May's bellicose response to the Juncker leak. But nevertheless, in legal terms, what's the issue now?
Well, the issue now, Kim, is that really everything is still up for grabs. It's up for grabs both at the European negotiating level and also locally. All that has happened, in fact, since the judgment in Miller has been a one-line act of Parliament which authorised the filing of a notice of withdrawal under Article 50 of the European Treaty and the commencement of negotiations. But what we've got now, and this is why, with respect, I think the political spat of this week is just politics.
Yes, but such fun.
Indeed. But is essentially by design and by choice of the British government, two processes which are running in parallel. One, the negotiation with Europe, which has barely started, and then secondly, the return again, yet again, to the British people for a further mandate for the current government.
So a further mandate, how will they decide that? What information will they have in order to determine that?
Well, precisely so, Kim. The calling of the snap election may have made very good political sense for a government sitting only with a 17-member majority in the House of Commons. But the reality is that the British public at the moment knows very, very little about the likely effect of the decision to withdraw from the Union. All it's got is a white paper from the government with 12 basic negotiating points. It's got the EU Council's position, which is at a similar level of generality. And the true reality of withdrawing from a union which Britain has been part of for 40 years and which now constitutes a whole third source of law, and most importantly, which provides 4 fundamental freedoms for British citizens as well as the other EU citizens, perhaps hasn't yet dawned. And if I may just make a small digression to events in this part of the world, one of the real significances of the way in which the European Union is structured was that it was structured on the basis of a set of freedoms which were for the people of Europe. And I think what we've realised in the last couple of weeks in our negotiations and discussions with our friends across the Tasman, that there can be a real problem with a very deep customs union which is not posited on a set of freedoms for the people of the countries.
I see the EU is demanding that Britain guarantees the pension, healthcare and benefits of all EU citizens living in Britain for the rest of their lives, with those rights guaranteed by the European Court of Justice. And those people must also be allowed to bring family members into the UK in perpetuity. As you say, that's a deal that New Zealand should have had with Australia. But all these demands, the $100 billion divorce bill that Britain is said to be needing to pay to the EU, the assets of the EU, the assets of Britain, back and forth. These demands aren't going to help anyone make up their minds about the terms of exit, are they?
Well,
it's just rhetoric at this point.
It's a negotiation, and one has to expect that the two sides in any international negotiation will start with their wish list of the things they most want to achieve. I think one of the encouraging things, just to be positive for a moment, is that it does look at the moment as though both the British government and the European Union are determined not to allow those European citizens that are currently living in Britain and vice versa to become bargaining chips in the process. And, of course, one hopes that that will be so, because what we're concerned with here is about 4 million people whose lives would otherwise be severely disrupted. But nevertheless, all the rest of it is for a negotiation. And there's a fundamental difference here. The UK continues to be a full member of the European Union and will continue to be a full member until it actually leaves. But the process of negotiating a withdrawal puts it in a completely different position for the purpose of the negotiation. It becomes effectively an independent state negotiating with the European Union on a bilateral basis.
But nevertheless, as an independent state and under those circumstances, it still can't go ahead and negotiate other trade deals until it's exited the European Union. Well, apparently.
It can negotiate independent trade deals with other states, but the effect of being a participating member of the European Union is that while it's still a member, it has to abide by European rules. So the effect is there can be negotiations, but nothing can be concluded until the position as to whether or not there is to be withdrawal, and if so, on what terms, is concluded.
Just as a matter of interest, Theresa May said no deal may be better than a bad deal. What if Britain says, nah, no deal, we're just going, see you later? What happens?
Well, so far as the treaty is concerned, the position is quite clear, which is that all European law would simply cease to have effect on that day, and Britain would just cease to be a member of the Union. But any thinking person on either side of the negotiation realises that would really be an Armageddon scenario. I mean,
why?
Because it's difficult to make accurate estimates. But
you haven't thought about that, have you?
I have
you
thought about that.
You haven't thought
Kim.
about that one.
I have thought about that because I'm very concerned.
Because it would be such an unreasonable response.
It would be an unreasonable.
What would happen?
Well, firstly, about a third of the UK statute, UK law book is European law. So the question of what the status of that would be would have to be resolved. But all of the other questions about the economic aspect of this would be much more far-reaching, because at the moment the British economy is utterly interdependent with Europe. You only have to look at the supply chain for the construction of a car or any other manufactured good to see that it's all posited on free movement. And free movement of goods and services only exists because of participation in the European Union.
Right. I mean, the laws that they're going to have to redraft after Brexit is just huge, isn't it?
It's the largest single project outside wartime that Britain's ever had to undertake in terms of legal reform.
Wow.
And
you should go back. Plenty of work for you back there.
Well, Kim, as you kindly mentioned in the introduction, and as your own career demonstrates, sometimes it's possible to sit on a perch in Wellington and still have an influence. Hopefully. But my point here is that the fundamental question which was exposed in the Miller litigation, what a remarkable woman she is, parenthetically, is still very much live, because what has not been resolved has been the vital role which Parliament is to play in that process of legal reform. And we've seen a couple of white papers from the British government, but the fundamental question of whether Parliament actually gets to substantively decide on the shape of the deal and to sweat the detail, those questions are all still up for grabs. And that is the principle that was vindicated in the Miller litigation. Of course, that's a principle that's very important that we should remain alive to here in New Zealand as well.
But she's still campaigning, Gina Miller.
She is. She's still campaigning precisely because she wants to try to see Parliament remain an effective, deliberative body acting as a check on the power of the executive of the day, as our constitution requires.
So what can she achieve now? Where is she going with this?
Well, you could put her on the programme, Kim. I'm sure she'd be delighted to speak, but my understanding is that she's encouraging the electorate to think strategically about the way in which they place their vote at the general election, so as to try to produce a broadly based membership at the House of Commons that will hold the government of the day to account.
I know that you're looking at the legalities, and I, being a superficial sort of person, tend to look towards the politics of it, and I'm not sure where they meet. I mean, if we look at the accusation by Theresa May that EU officials have been interfering in the UK general election, that was interpreted, that sort of pugnacious reaction was interpreted as playing to the Leave voters who want Britain to look strong. And indeed, the results of these local elections seem to vindicate that, because the Tories have, done extraordinarily well.
Well, it might play well locally, but any astute politician would also realise that if, as I think we both agree, a negotiated deal is inherently much more likely to be more beneficial to the UK as well as to Europe than exit without a negotiated deal. You've still got to turn around the next day and deal with your negotiating partner on the international plane.
Yeah.
And so there's only so far you can go in bolstering your position at home if, in fact, you're still faced with a set of really difficult issues to resolve on the internationally.
One European commentator has written that the outcome of the Brexit negotiation has to be Schrödinger's cat, he said it was like, has to be simultaneously a great success for the British government and an abject failure for Britain in the eyes of the European nations. And so the EU negotiator can only succeed if Britain is seen to fail, and each have very different audiences.
That's true, but that's of course often true of many international negotiations,
Yeah.
and a big effort will have to be made on both sides, firstly to try and remain a bit calmer than has been the case this week, but secondly, ultimately to present the deal that is negotiated in a way that plays successfully to their local constituencies, as well as achieving the best result. And that one of the ironies of all of this is that in the Brexit campaign prior to the referendum, much was made of the repatriation of sovereignty and the conjuring with this idea of a Great Repeal Bill. The Great Repeal Bill, at least in the form that we've seen it in the White Paper, is actually a Great Continuation Bill, because the reality is that Britain needs a vast amount of the EU law that is currently applicable in the UK, and is going to have to continue to apply it even when it leaves the European Union, assuming that it does.
I was quite interested in the European Union saying Britain can't expect to get back any money from the EU because it's not a company. There's no refund if you pull out. Does that accord with your understanding?
Well, I'm no expert on the financial arrangements of the union, but the fundamental point here is that this is a regional economic organisation into which each member contributes according to a rolling program of contributions. So this is not an organisation that's being wound up. After all, it's still got a substantial number of other members, 27 members.
Yeah.
So the organisation will continue. Britain's commitments, as they exist at the moment, have been made, and so what we're talking about is the working out of the honouring of those commitments. I think it's scarcely conceivable that Britain would simply walk away from commitments which it has assumed.
No, that would be a bad look, wouldn't it, apart from anything else?
Well, what this is in part about is about Britain reasserting its own independent stature on the international stage. And to that extent, of course, I'm very supportive. I suppose I've been a great admirer of Britain all my life, and I started my first job at the Commonwealth Secretariat, so I have a great understanding of Britain's independent place in the world. But I think the important point from our perspective here in New Zealand is that what we need here in New Zealand is a rules-based international system. And what we're seeing at the moment, which is a matter of grave concern, is a substantial number of larger states on whom the peace and security of the world depends, choosing to turn away at critical points from key pillars of the international legal system. And we have to speak out to say, to defend the principles underlying that system. Because after all,
who are you talking about specifically, apart from Australia?
I wasn't seeking to make a direct criticism of Australia, but we do in the United States have a president who campaigned on a platform of withdrawal from various international agreements. We've also had experience recently in the context of the law of the sea of 2 other permanent 5 members choosing not to participate in the compulsory dispute settlement mechanism, which they voluntarily signed up to when they became parties to the convention. So, and then there are many other examples of other states also at the moment choosing to withdraw from agreements. So I'm not saying that states are bound by international law commitments for all time. The point of a treaty is that it is a voluntary engagement which you can choose to withdraw from. But what I am saying is that the underlying principle of commitment to a rules-based system is one that we've got to stand up and defend, because at the moment that's really under threat. The European Union was never principally about economic cooperation. It was about ensuring that the nations of Europe did not go to war with each other. And the framers of the Union saw close economic collaboration as a means to ensure that larger objective of peace and security. If you depart from that in favour of merely adventitious diplomacy from day to day, the world becomes a much more dangerous place.
Thank you, Professor Campbell McLachlan. No doubt there will be more to come on that Brexit issue.